Get ready? Start. A writ of certiorari can be issued for correcting errors of jurisdiction committed by inferior courts or tribunals, semicolon. These are cases where orders are passed by inferior courts or tribunals without jurisdiction. Stop. A writ can similarly be issued where, in exercise of jurisdiction conferred on it, the court or tribunal acts illegally or improperly, as, for instance, it decides a question without giving an opportunity to be heard to the party affected by the order, or where the procedure adopted in dealing with the dispute is opposed to principles of natural justice. Stop. There is, however, no doubt that the jurisdiction to issue a writ of certiorari is a supervisory jurisdiction. Stop. This limitation necessarily means that findings of fact reached by the inferior court or tribunal as a result of the appreciation of evidence cannot be reopened or questioned in writ proceedings. Stop. An error of law which is apparent on the face of the record can be corrected by a writ, but not an error of fact, however grave it may appear to be. Stop. In regard to a finding of fact recorded by the tribunal, a writ of certiorari can be issued if it is shown that in recording the said finding, the tribunal had erroneously refused to admit admissible and material evidence, or had erroneously admitted inadmissible evidence which has influenced the impugned finding. Stop. Similarly, if a finding of fact is based on no evidence, that would be regarded as an error of law which can be corrected by a writ of certiorari. Stop. In dealing with this category of cases, however, we must always bear in mind that a finding of fact recorded by the tribunal cannot be challenged in proceedings for a writ of certiorari on the ground that the relevant and material evidence adduced by the tribunal was insufficient or inadequate to sustain the impugned finding. Stop. The adequacy or sufficiency of evidence led on a point and the inference of fact to be drawn from the said finding are within the exclusive jurisdiction of the tribunal, and the said points cannot be agitated before a writ court. Stop. It is within these limits that the jurisdiction conferred on the High Courts under Article 226 to issue a writ of certiorari can be legitimately exercised. Stop. Thank you.